Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Here, we bridge the gap between technology and the law, bringing you the forefront of electronic discovery. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery. With over 20 years at the junction of law and technology, I'm excited to help bring together leading experts and practitioners who provide a wealth of knowledge on electronically stored information.
And my name is Brandon Mack. I'm the co-host of our podcast. And with 2 decades of eDiscovery experience myself, I'm also thrilled to be able to participate in bringing you information and education around the world of eDiscovery.
NeLI is not just about discussions. It's about education and it's about collaboration.
Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note that while we engage with some of the brightest minds in the field, the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. Welcome back to another NeLI Pod podcast. Today, we are joined by the one and only Tom Gricks. Tom, man, it is always a pleasure to see you. Thanks for joining us in the virtual recording studio here today.
Likewise, and I'm sure you appreciate the fact that there's only one. So it's always a pleasure.
I do, actually.
It's always a pleasure, Daniel, to see you and Brandon, always.
Well, for those that are listening, Tom and I have gone quite a ways back, so there is often on and off camera a lot of banter between the both of us. Tom, for those that don't know you, I want to start off just with a little bit of a background about you. You have a really interesting and really great story to tell. And it starts a little bit untraditionally. And when I look back at what you have done, Tom, and your career trajectory, you didn't start off being a poli-sci major and then going right to law school, as some have often done. You actually graduated with a degree in engineering, worked in engineering, and then made your way to law school. Can you tell us a little bit about that journey?
Oh, yeah. Like everything with me, it was it's just happenstance that it goes that way. I am not kidding you. I ended up at CMU in chemical engineering simply because the guy that I was following through high school, who I thought was brilliant, went there, and I'm like, well, if he's going to do this, I'm going to try this, right? So I go. I end up graduating with a degree in chemical engineering. And I go in to work with Draveau Engineers. It no longer exists. It was a company in Pittsburgh, an engineering construction firm. And honest to goodness, Daniel, I had no desire at all to go to law school. I'd never even thought about being a lawyer. And then I looked around and I'm like, man, the only way you get ahead at this place is to have an advanced degree. I said, I am not going back to engineering school. They are way too geeky for me. And I looked around and I'm like, boy, there are a lot of MBAs. I'm like, you know what? I'll go to law school. I like Perry Mason. Let's give it a go. So that is the amount of thought that went into me going to law school. And that's why I started it. And I will tell you this, what I thought was very interesting is really the difference between being an engineer and being a lawyer. And I've explained it this way to people before. When you're an engineer, you know this. 2 + 2 is always 4, right? When you're a lawyer, 2 + 2 doesn't necessarily mean 4. And in fact, oftentimes it's not even 2 + 2. It was so different that it took me a while to ever bring all of that together.
When you say it took you a while to bring it all together, how did it come together? Because I understand, and I think that's a great analogy, that the problems in the field of law aren't as discrete as you might see in engineering. But I feel like both professions are about problem solving, about essentially engineering a solution to a problem that's presented to you. How did you eventually get those two ways of thinking to kind of fall together and mesh to have the career that you do now?
Brandon, I think you're exactly right. I think what I really did was came to grips with the fact that I could actually use my engineering techniques to get to legal solutions that I wanted to, right? I could start to analyze problems in an engineering way, saying this is, I need to know all of the facts. I need to define the problem, and then I need to find a solution to that problem, knowing what I have as tools to do it. So I ended up finally saying, I can actually mold these things together by using my engineering kind of technique to get to a legal solution. And so that's really how it came together. And thankfully, I was this close to quitting after the first semester. This close. After that, it was after that point that I realized I could actually make the two of them work together.
So that's really interesting that you found this marriage between engineering and the law. And then you went on to practice, and along comes this technology that exists in the early days. People are calling it different things. It's called computer assisted review. It's called predictive coding, called technology assisted review. And again, for those that may not know who you are, you became quite an icon, quite a figurehead, if you will, for this technology. Do you want to walk into that a little bit and explain what in the world I'm talking about here, Tom?
Yeah, I will. And I need to preface that by saying I want you to understand that I argued the first case in the country
So,
where,
so also, so for some context there, so there were a couple of cases right in the early days, and when I say a couple, I mean literally two. There was your case, Tom, and there was also Judge Peck, who will also be on the NeLI Pod program, and I'll have well, Brandon and I will get, of course, Judge Peck's point of view, but please, counselor, continue.
well, you need to explain to Judge Peck. See, I was the first person to argue against the opposition
Yeah.
when I suggested I wanted to do tar. And as I've told Judge Peck, he didn't have to argue with anyone. He was a judge. All he had to do was pull out that paper that he had written 10 years ago and he kept trying to write. And he would then dust it off, and that became De Silva Moore. But Judge Peck doesn't agree with me. He will never agree with me. Feel free. He will have the same type of reaction when you talk to him. But so you got to love, like when I told you this all is through happenstance, you got to love how this works, right? I'm sitting at Schneider, and we were
Schneider's
representing.
the law firm that you work for
Yeah,
context.
yep,
Sorry, go ahead.
yep. It was the law firm, and we were representing UPMC, the University of Pittsburgh Medical Center. And there was going to be a big review. And they were technically represented primarily by New York counsel. So at that point in time, I had started to look at technologies that would actually save time and money in eDiscovery against just a standard review. I'm reading all of this stuff. I'm kind of learning it, and it gets suggested by New York counsel. In fact, not suggested. They actually basically hired 150 people to come in and do the review before they even talked to the client. I mean, it was odd. And I went to the lead litigator, our elder statesman, and I said, Paul, we don't have to do this. I said, well, there's absolutely no reason we should throw 150 people at this. We can do a much better job with some of the new technologies. And in that point in time, there was more than anything else, it was TAR 1, right? And Maura was probably out there. Maura and Gordon were probably out there doing their Cal work as well. But most
And
folks
so,
were
sorry,
using
just for
TAR 1.
a little more context, those that don't know, that's Maura Grossman and Gordon Cormack, who really have set, back then it was the gold standard, so to speak, no pun intended, on understanding what technology assisted review was and the benefits of being able to use it. Published many different articles, and worth for those who don't know, it's worth going back through the archive and taking a look at
Agreed.
those.
Agreed.
Yeah.
So anyway, that's how I started getting involved. And through that case, I ended up going to conference after conference and learning more and more and more about technology assisted review. And I got introduced to a lot of folks who were doing technology assisted review at the time. And at the same time, I'm practicing, right? And I was working on a case with my good friend John Stern, who's an aviation lawyer, and it dealt with the collapse of the Dulles Jet Center on $400 million worth of aircraft. And he calls me up one day and he said, "You really believe in this technology assisted review stuff?" And I said, "I do." And he said, "You want to do it?" I'm like, "Yeah, you bet I want to do it." I'm like, "Cool." So I got to tell you, nothing ever goes exactly right for me. So I told John, I said, "Okay, I'm going to call these guys up." I looked at the data, Daniel. I'm sorry, I can talk about this forever, but I looked at the data and most of this stuff was not responsive, right? We had like 2 million documents at the time. And at the time in 2011, that's a lot of documents. And I looked at it and I said, there is no reason for us to look at most of these. Let's use TAR and let's eliminate this and get the documents out there and get this case tried. Because one of the other things that I did was I practiced in-house for 5 years. And being in-house, I have a real appreciation for budgets and reserves. And nothing can blow up budgets and reserves in a litigation like eDiscovery. So I said, let's use TAR. So I called up the lawyer for the other side and I said, "Hey, look, I'm telling you, there's not much here. Let's do TAR. I will not only let you have your nose under the tent, you can sit at the table with me. You just can't look at privileged documents." I said, "We'll make decisions. We'll make them together. We'll figure out what's good. We'll let the tool do its job. We'll make sure it worked. We'll validate, and then we'll go forward." And the answer that I got was, when I do reviews, I sit down and look at every document. I just don't feel comfortable with this new technology. Seriously. I mean, seriously, you don't believe that somebody's going to say that, right? And I said, "Well, if you're not going to let me, I'm going to ask the judge." And so I filed a motion for protective order to permit me to do TAR. That's how that all happened. Because in the simplest of all worlds, which is let's get these documents produced and try the case, his answer was no. So that's how we got the global.
When you look back at the global case, what do you look at as sort of its contribution to the field of TAR? As we talk about TAR, I know my personal opinion on when I think of global, what's the one thing I take away from that case, but how do you think that it impacted the growth of acceptance of TAR at that time?
Brandon, the answer to that is, if you want to know how I feel it did it, I feel it didn't do it the way it was supposed to. I can tell you this. I looked at that case, and what we ended up doing is, at the end of the day, out of a 2 million document set, we only had to review 200,000 documents. That was it. So I was like, man, this is absolutely fantastic. This stuff is phenomenal. People are going to jump to be able to do this type of review, to the point where I was so worried that people were not going to do a good job of producing documents and weren't going to adequately discharge their Rule 11 responsibilities, that I wrote the paper with Carl Shinneman on the implications of Rule 11 on that. Because the one thing when you do TAR is you're leaving responsive documents behind, right? So you have to be comfortable that you have actually fulfilled all of your obligations for production, and you do that by validation. And so I kind of went around and round about how you can do validation. And I think the nice thing about Global is it gave people a roadmap for things they could do if they wanted to. That was really, I think, what it contributed. It's there. The briefing was all available. You could go in and get it, and you can see how and why to make these arguments about the efficiencies of TAR and the value of TAR.
There was a lot of criticism, Tom, in the beginning with TAR about how, yeah, this might be good, and the but was usually that it's going to take too long for a senior partner who has a very high hourly dollar figure associated with them, and they have to sit there and create a seed set. And they have to sit there, they have to pretend they are a data scientist and basically train this program. For you with an engineering background, this is fantastic, right? I got this. But for a lot of folks who are not tech savvy, who don't really understand, don't have an engineering background, this was all black box, and I don't know it. I can't understand it. I don't trust it. I'm not going to use it, and it's going to take me too long to just get it up to speed and let this thing hum in order for it to actually prove its overall value. Do you think that's some of the reason why that it didn't take off the way that we would have thought after your decision, after Judge Peck's decision?
I do think it's the general tendency of lawyers to be skeptical about just about anything. As an engineer, it was so easy for me to understand because it is a black box, because stuff happens that you can't see. But you've got to understand that everything you do is very, very easy. You just look at documents. That's all you got to do. It's really simple. And at the end of the day, you just test it to make sure you did a good enough job. Now, that was my concern, to make sure that that test was done appropriately to prove that you've done a good enough job so that you're discharging your obligation of reasonable inquiry in a production. Because I was an engineer, I had a hard time understanding why people didn't go with this, because it was so simple. And it's always been that simple. You make decisions on documents, they get coded, you test them. It was that easy. Lawyers just, I think there is a tendency to be risk averse and to not trust what you don't know. And then we got into lots of fights about validation and does it really work? And do I really see what I'm seeing and all that kind of stuff. But I do think that my engineering background made it a lot easier to accept this. I think we were talking about this when we were preparing for this. I mean, when I was in engineering school, the one thing that I found out is that you can model anything. In fact, my senior project as a chemie in computing was to model the temperature distribution of a cancerous tumor given changes in blood flow and changes in external temperature, right? So I'm like, shucks, you can model anything. You really can. And this is all about really smart people, not me, but really smart data scientists telling us how to build these models. And it worked. I mean, it truly did work.
You mentioned, Tom, that at the time that you were dealing with Global and you're preparing for that and arguing that case, you suspect that out there in the ether somewhere were Grossman and Cormack working on their version of what TAR was going to look like. So can you talk to us a little bit about what that evolution looks like from your perspective, having gone to the match to argue for TAR in the 1.0 iteration, then seeing this evolution of the tool or the evolution of the process? What's your perspective on that growth from TAR 1.0 to TAR 2.0?
I think it was fabulous. I mean, it was really, for me, it was fantastic. It was not easy though, because the difference is you got to review more documents with TAR 1 than you do with TAR 2. That is almost a given. So, okay, I'm looking at TAR 2 and I'm saying that's not a bad idea. I like what's happening here, but the way Maura and Gordon, the way Cal started, it was almost purely relevance feedback, which means nothing more than I'm going to keep giving you things that you said you like. And my concern was always, if I keep pointing the ship just in the direction of the things that I like, I'm going to miss all these responsive documents over here that I don't know anything about. So I was very concerned with that. Maura and Gordon got past it way back in the day by doing some measure of random sampling and making sure at the end of the process that those documents were being considered. Frankly, I got past it when I got introduced to the folks at Catalyst, to John Tredenick and Dr. Jeremy Pickens, who had created a Cal tool that incorporated an algorithm that would go look for the things you didn't know. I was talking to them about it, and I said, you guys have to understand, you have solved my problem. That was my problem with Cal. And I said, you have solved my problem now that I know that I am actually exploring the entire universe and looking for responsive documents that I may not even know exist today.
And that right there, Tom, I think was what I like to call really the next iteration. That was a big difference maker. And what you're talking about right now, and correct me if I'm wrong, what you're talking about is contextual diversity. And
Right.
that is, and so you went over, so you stopped practicing law, you joined John over at Catalyst, joined Dr. Jeremy Pickens, and together you all had created something that the country had not seen before as it relates to Cal. And this was almost, I would say, an inflection point. When you said that, you guys solved my problem, you're talking about solving for a negative in a sense, right? What do we not know within
Right.
the corpus of data? Is that right?
Yeah. Look, the point of creating a model is very simple. The point of creating a model is so that you can have that model look for things that look like that model. But when you're doing a production, when you're doing a review for production, what you don't know is exactly what you said. It is what you don't know. You don't know what else is out there that has responsiveness, has relevance to your case, but it's not something that you've been really looking for. So a pure relevance feedback model will miss it. But unless you happen to find it, what's going to happen is you're going to run out of responsive documents in your review. And when you run out of responsive documents in your review batches, you're pretty much done. That's true with contextual diversity. Without contextual diversity, you could never really be quite sure. So contextual diversity was a game changer for me. I thought it was critical.
It was critical for you, not, I don't want to call it in an academic sense, but in a real world sense, it was critical for you because you understood the problems of the way we had been sampling, the way the first versions of Cal really deployed sampling, and where the holes were in that workflow. From your perspective, when you saw that second version, when the contextual diversity was introduced to what a Cal workflow looks like, how did you see that changing workflows? Because I think it's easy for all of us to see, the big difference between when I had to do manual review to then when I started to be able to use TAR. Then when we started talk about TAR 1.0 versus TAR 2.0 or Cal, we can see a big difference in the change in workflow between those two. But when we're talking about Cal using the different types of sampling, the way in which it enables you to do different things, I don't think is as obvious to people who aren't steeped in what technology assisted review is. So from your perspective, where does the rubber meet the road on that differentiation in the two approaches to Cal?
It's interesting that you ask that, because where the rubber meets the road is in my discussions with opposing parties that I'm producing documents to. Because their question invariably to me is, well, how do you know that you get this stuff? How do you know? There may be stuff out there. And I said, you don't understand. The way this algorithm is written, it is constantly going out for thematic groups and looking at them and trying to find the best document and putting it automatically in my batch. But now, as soon as I've seen that document, I know that it's either good or bad. So now my model is considering the documents that I didn't know a minute ago, and it's pushing me ever so slightly in a different direction towards something else that I probably need or not. So I've had conversations with opposing parties where they said, oh, well, you've got to really do an awful lot of validation here and there and look at all different places because we never know whether you've seen all this stuff. And I said, the nice part about this one is this workflow, I don't have to do any of that because it's automatically built in. When I get through this, I know that the amount of documents that remain on any thematic group is very low. So, we still validate, we still do all of that, of course. But at that point, I don't have to worry about it. That's what I've talked to folks. I don't have to worry that I'm missing something because it's in there.
When you all published a book called Tar for Smart People, I thought that was no pun intended. I thought it was genius, right? It made sense. Obviously, I read the book. In full disclosure, I did work for Catalyst, and when I read that, it was part of the reason that I went to Catalyst to begin with was because I'm like, these guys, they understand it, they get it, and I got hooked in and drank the proverbial juice, etc. But do you think, looking back though, similar to the question that Brandon asked you about whether or not you think that the country has finally latched on to even Cal 2.0 at this point, and this is 14 years later.
I love to hear all the people that say, oh, don't worry, TAR's accepted, everybody does it. Yeah, no, they don't. It is still sometimes a fight. I know huge corporations that I've worked with that won't use TAR. And one of the reasons they don't want to use TAR is they don't want to have a fight with opposing counsel about what's going to be in the ESI protocol. I'm really, me, I'm not opinionated on anything. But the fact is, the reason they don't want to have that discussion is because they just don't understand it. Let me have that discussion because I can tell people how well this is going to work and it will solve problems. We waste so much money on discovery. It's interesting because, like, I'm an eDiscovery lawyer. I hate spending money on eDiscovery. I really think that we need to drive that down, and we'll get to that as well in terms of other ways to drive that down. But it's always been my goal to bring that cost down. And this is a way to do it. And if I was on a podium on a panel with a woman from Ropes and Gray at one point, and somebody asked her, "What algorithm do you use?" She said, "Here's how it works. I take all of my documents and I spread them out into a big field, and I have a magic cow. And my magic cow steps on every document that I do not need to produce. So I pick up all of the documents that are clean at the end of the day, and I give them to you. And I can prove to you those are all the responsive documents. Why do you care?" And that's the thing. I know statistics are statistics, and I know people worry about that. But in reality, if you go back and look at what we used to do, I don't know about you. I sat there and flipped through folders of documents, and sometimes my review went, there's nothing in there. Just like, didn't look like it was a folder that was going to matter. So I didn't look, right? You got a worse job without the technology than you will get with the technology. And I can show you that. So we shouldn't be fighting about that anymore. Yeah, you may want to worry. Is it a big sample? Is it a little sample? That kind of stuff. But otherwise, no, it really is a better deal. And that's really what we should be focused on.
Industry adoption aside, do you think that Cal in the 2.0 version, does it still have room to grow? I think one of the challenges that we've got in eDiscovery is that the world of technology and the world of information creation is constantly evolving and constantly growing. Is it leaving some of the tools that we use for Cal behind? Is there still room for Cal to improve on dealing with things like short messages or types of data that don't fit into, the typical alphanumeric data that we were using when we first stumbled upon this, 10 years ago? Is there room to grow, or is it time to look somewhere else for a solution?
You can use a combination of the two, but responding to the first question, the answer is if Dr. Jeremy Pickens will join me again, there will be growth. Jeremy and I were working on, you can't imagine the things we were working on. We were working on image tar. We were working on multimodal tar that would look not only at the text, but at the date, at the sender, at the recipient, to start looking at the factors that would influence the model and influence the efficiency of the model. So yeah, you can make it better. There's absolutely no doubt. When Jeremy and I worked together, we were constantly making improvements all the way along anyway. And now we've got new techniques that we could look at. And when you move into the world of where technology is today, AI, for example, there's still room for tar, is in my world. Even putting Gen AI aside, tar can improve without a doubt, can do more.
So you said the magic word. So let me transition. I think it's a good point to bring out, and we've talked about this before as well, is that TAR, CAL, however you want to call it, it is a form of artificial intelligence. It does fall under the umbrella of artificial intelligence. So, but you talk about generative AI, and that's obviously what everyone's talking about. When people say AI today, I think it's a pretty fair statement to suggest that they're really talking about generative AI. And when we look at the state of eDiscovery, I feel like this is deja vu all over again. It is harkening back to 14 years ago, where all of a sudden everybody is saying, well, this time I've got the best LLM. No, I have the best LLM. When really the underlying algorithm, the underlying technology, it's really the same. It's utilizing Microsoft OpenAI as an example, right? There's others,
Right.
obviously, but there's an example. It's then what you do with it from there. And there's a lot of suggestion that, well, this is going to be like the greatest thing since sliced bread. Move aside tar, move aside cal, whatever you want to say, and let's bring in generative AI. But it's interesting. I read a recent article that suggested that, well, wait a second, perhaps maybe we should temper that excitement. Somebody referenced actually the cycles of innovation. And I looked at that and I thought, well, that's really interesting. And then when people start getting getting into the specific document review software that has leveraged it, there's a lot to be said about how to be able to manipulate it just right. And I almost got the little cringe moment where I'm like, oh my gosh, this is going to be like TAR 1.0. How do I have to train the prompts correctly in order to get the right answers? When you take a look at generative AI, you see what all the hype is about. What are your thoughts about, is this really the next iteration? Is this the next big hype? Is this not for real? What are your thoughts?
Let me put it to you this way. Every 45 documents ish that Gen AI finds saves you an hour's worth of people's time. Is it going to save you every dime of people's time? I don't know. I doubt it. I expect that what we're going to end up doing is having some measure of Gen AI tied with review. I expect that's what's going to happen, at least until we really, really, really learn how to refine prompts. But although I don't know. I don't know where that's going to go. I'm in the process of doing a lot of testing on this to see any number of different things and how they will impact it. I look at Gen AI and I believe that it will benefit the process. It is, though, Daniel, as you said, it's essentially TAR 1 in sheep's clothing. It is, generally speaking, the same thing. You are building a model. It's a different model to approach the problem from a different way, but it is an effort to build a model. It happens to be a big neural net model, right? That none of us are going to understand, but it's a model nonetheless. And you're trying to build that model to reflect a way or to find a way to grab the documents that you need. We'll get there. It's going to take time. It's not today. I mean, I was telling somebody earlier, I read an article where someone said, oh, the client has saved 70% of its costs using Gen AI. And I started reading it, and step 1, apply keywords. And I'm like, well, that's just not fair. Okay. No, you can't take credit for that. So yeah, it'll get there. It's going to take a while. But Brandon, back to some of the stuff that we talked about, you've got people on the other side you're going to have to deal with on that.
Right. Yeah. I mean, you say it's going to take a while, and you've talked a little bit about some of the barriers we still see just to TAR 1.0, 2.0, people who don't want to use it. I agree with you that a lot of it is not understanding it, not understanding how it works, makes you hesitant to jump in with it. Do you think we've learned anything over the last 12 to 15 years in trying to adopt the technology that is TAR that will help us be better or faster at the adoption of using generative AI as part of our toolkit now?
We have done a good bit to get people to understand validation. I don't think it's 100% of the way, but more than half the people that would have argued against me before were arguing on the issue of validation and happy with it today. We've already moved much further down the line than we used to be, because you now know what you're seeing in terms of validation, what types of validation approaches, what kinds of numbers, what kinds of analysis need to be done. So I think that's going to improve on the acceptance of Gen AI. My guess is that will help. We're still going to have folks who are skeptical about it. And look, there is a reason for it. I was telling somebody this the other day. I said, here's the problem, and you need to understand it from the perspective of the requesting party. Because look, I'm not suggesting that I want people to do this. I just know they will. They are going to want to see my prompts. And I will tell you why. This isn't rocket science, because you know what my prompt says? My prompt says, go find me 80% of the responsive documents, but make sure you never include a hot one. And if that's my prompt, you've got 80%. Yay. And now, look, I'm not accusing folks of doing that. I'm just reflecting on the fact that those who have a concern about validation have that concern, that stuff they really want is going to be missed. We'll get there. It ain't tomorrow.
So speaking of which, when we look through 2025, 2026, et cetera, 1 year, 3 years, what does that look like? Because when I see the trajectory of where we are, and you said, we'll get there, I anticipate 2025, there's going to be, if people start utilizing it, a lot of discovery motions about, prompts, about what kind of prompt did you use and show me what your prompts are, no differently than what we saw with the algorithm with TAR. We'll
Right.
maybe get that magic cow in like you were talking about before. But there's a possibility where you have a world where there's Gen AI plus Cal, or Cal plus Gen AI, or maybe do the trifecta. You've got keyword search, you've got Cal, you've got Gen AI,
Sure.
whatever it is. you're minimizing the amount of overall documents that you've got, and you focus it on the substantive work if we possibly get there. Where do you think we're going to be in the next 1 to 3 years as far as, you've seen the trajectory? I mean, you've been at this. Where are we going?
It's going to head in the direction of focusing on AI generally, right? And the theory that AI is going to be able to identify documents. You run the documents through the AI, it gives you the stuff that's responsive. We're going to have people focused on prompting. We're going to move in the direction, in my world, we move in the direction of building AI together, Gen AI together with TAR, so that TAR is always suggesting the next most likely responsive document, but your AI is doing the decision making, right? At the end of the day, you have actually reviewed the least number of documents you possibly can because you get down to the bottom and you see there's nothing left. The other thing we're going to do, there are two things that I want to see happen. One is, let's build in the QC loop into that process so that the feedback that the AI gets is the same feedback that a lawyer would have gotten when they were doing the review memo. So now we're constantly updating the prompt to make it much better at finding those documents. So let's figure out how to build in that QC loop. And the other thing I want to do, sorry to the law firms out there who want to spend all their time crafting review memos, but one of the tests that I'm running is, how can I take the complaint, the answer, the RFPs, and then go to the data set. And my first prompt is going to be, hey, here's a complaint. Give me the top 10 documents that support this and the top 10 that refute it. And then I'm going to go, here's all my stuff, AI. Craft me the right prompt to go get these documents. And I just saved you 100 hours of attorney time. That's where I think we need to be looking at every component of this process and finding out how we optimize it for all of the tools that we have available, and make sure that we're squeezing every last ounce out of it to keep the cost down and bring the efficiency up. And heck, think about this. We may actually get to try cases again. Oh my gosh. I mean, that was my biggest problem. I like to try cases. I hate discovery.
Yeah.
You just take my documents, you can have them. Let's go try the case.
I think you might have a marketable idea there, Tom, because I don't know that I've ever met an attorney who really loves spending time writing review protocols. So I think you'll save a lot of people a lot of time and headache. And we could, this topic, this has been a fascinating conversation, and we could talk about any one of the things you've brought up for another hour, just on each of these elements that we're talking about the evolution of TAR. But one of the things that we definitely wanted to hit while we have you is to talk about your involvement with NeLI and the sponsorship of NeLI. Why NeLI? The world of eDiscovery and eDiscovery education has a lot of different participants, and there are a lot of conferences that demand time and preparation from all of us. When we make choices where we're going to spend that time, it means something. So I'm curious, for you specifically, why is NeLI a conference that attracts you and has attracted the sponsorship that you've given to NeLI and your ongoing participation?
Really, for me, it's pretty simple. I've been to every conference. I've been to just all over the place, to different ones. And my own view is that NeLI provides the best substantive material to people who are practicing in this area and need to know what to do, where to go, and how to do it, what tools are available, what you can expect, what you're going to see. The way that process is put, and it's so nice because it's a small kind of auditorium setting that everybody sits down, questions get asked, questions get answered, and you don't have to go look at different places to go, different sessions. We all get to learn together, and that has the benefit not only of the speaker and what that speaker can give to the audience, but what the audience can give back to that speaker and what the entire group can take away. And I am telling you, in my view, it provides the best substantive material of any conference going today.
That's fantastic. That's quite an endorsement. And Tom, it really is always a pleasure whenever I get to talk to you informally, but here on the podcast. It was really great for you to be able to provide your contributions to all of the NeLI Pod listeners and get a better idea about who you are and your thoughts around this space. It really is a pleasure. And we thank you very much, Tom.
Oh, man, it's great to be with both of you guys and have the opportunity to do this. Thank you.
Thanks, Tom.
If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in eDiscovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of eDiscovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.